Hello viewers and welcome to the third episode of Departmental Enquiry. In the last episode, we have seen the procedural part of an enquiry. Now in this episode, we are going to discuss the enquiry report and punishment. Now let's see what an enquiry report is.
After the inquiry is over, there must be some findings as regards the inquiry. Or in other words, you will appreciate that after a trial is over, there must be a judgment. This judgment is nothing but the inquiry report as regards the inquiry. Now what is this report? We have already served a charge sheet, so the report should contain a charge sheet. What are the charges? It should also contain the versions of the various witnesses. It should also contain the cross-examinations. It should also contain as to what is the evidence which comes out of either of the parties. There must be a scanning of the evidence on record. There must also be the reasons. This is most important. Only giving findings might even constitute a serious infirmity. But however, the findings should essentially be supported with reasons. Then and then only we can conclude whether the charges are proved or not proved. So all these things should be contained in the inquiry report.
Now let's see, is enquiry report at all necessary? And what are the contents of an enquiry report?
It's an absolute must that there must be an inquiry report. Or in other words, to report the findings is very mandatory as regards the inquiry officer. He must report the findings, whatever he has observed in the inquiry, else that would constitute a serious infirmity and the whole purpose of the inquiry is defeated. Just think of a situation that you have a trial and the judge does not deliver a judgment. What is the use of having a trial? And one more thing, why should he submit his findings, that to reasoned ones, so that if at all these findings are challenged by the workmen before the labor court or the industrial tribunal, the court will have an opportunity to find out whether the findings are perverse, whether they are erroneous, whether the inquiry officer has transgressed the normal rules or the normal limits within which he has to function, or some extraneous matter has guided him to or forced him to deliver such sort of an inquiry report. All these things have to be taken into consideration. But for all these things, an inquiry report is a must. But what should it contain? An inquiry report should be a moderate one. That is, it should not be too short, it should not be too long. It should also not be a PhD thesis, it should not be an exercise in fantasy. No unnecessary adjectives be used in the inquiry report. Say for example, you have an inquiry report of 1200 pages for a simple charge of an absence of a day or two. Why do you have to have such a big report? Well, some people have even commented this way, that God punishes novelists of the yester birth by making them inquiry officers in the next birth. Forget about the joke, but we also keep in mind that unnecessary things or unnecessary adjectives, say for example, the workman is a black sheep of the industrial family, or he is not fit to stay in the industry, or he will ruin the economy, or he is not even fit to stay on earth, or say he is a rotten mango. Things like that, the use of such things should be avoided at any cost, because such things have got an emotional bearing. What we have to see, or what the inquiry officer has to see, should have a nexus with the evidence and the versions of the witnesses, and he should not base his report on pure emotions.
Now, should the findings be based on charge sheet? And can the past record be considered for punishment?
The charges should essentially be based on the charges which are contained in the charge sheet itself. Else, how are you to substantiate your inquiry on a charge which is basically absent in the charge sheet? Well, that would be erroneous. And all these things should be present in the inquiry report. The inquiry report should contain as to on what charges the inquiry is conducted, else how will the industrial tribunal understand that whether the findings of the inquiry officer are perverse, they are based upon the evidence on record, they are based upon things which are not in the evidence on record, or his findings are erroneous. Ultimately, the inquiry officer also has to conclude his inquiry report and suggest something. So how is the industrial tribunal tomorrow in a position to find out whether the approach of the inquiry officer was right or wrong? In simple words, what is expected out of the inquiry officer is that there must be a scanning of the evidence on record. However, one is to remember this thing also, that inquiry officers are not lawyers, so too much of legalism is not to be expected out of them. And at the same time, their inquiry report should not be brushed aside just because they are not lawyers. As regards the past record is concerned, past record only adds an additional weight to the inquiry report, which is to be seen if at all given to, that is whether the past record is given to the inquiry officer so that he suggests some sort of a punishment. Now he may suggest a punishment, he might not suggest a punishment, and in this context the rules of the particular organization or the standing orders are to be seen. But if the inquiry report is based upon the past record, it is again a wrong report, for the simple reason is that the inquiry report should essentially be based on the present charge sheet and not on the past record. But past record can certainly be seen if given to the inquiry officer to suggest a punishment, so that he suggests some sort of a proportional punishment, or even the disciplinary authority understands as to what sort of a punishment is to be given. Ultimately, the punishment is meted out not by the inquiry officer but by the disciplinary authority. At last but not the least, the most important element as regards the full inquiry is, as per a very recent ruling of the Honorable Supreme Court, a copy of the inquiry report must be handed over to the delinquent or the charge sheeted employee or the charge sheeted workman.
Now let's see an everyday happening in an industry.
सर, क्या आप जानते हैं रमेश के डिपार्टमेंटल इंक्वायरी के बारे में कंपनी में तरह तरह की बातें चल रही है।
हाँ, जानता हूँ। हर आदमी इसके बारे में अपनी राय दे रहा है।
मैं भी कुछ दिनों से इस बात पर गौर कर रहा हूँ। आप तो जानते ही हैं सर, मैं रिसेंटली ज्वाइन हुआ हूँ, फिर भी इतनी सारी बातें सुनने के बाद सही क्या गलत क्या कुछ पता नहीं लगता।
माय डियर मिस्टर जोशी, मैं जानता हूँ आप नए हैं, जवान हैं, और इसलिए मैं सोचता हूँ कि इस विषय में आप किसी भी गलत बात का शिकार न हो।
मैंने तो सुना है कि रमेश की इंक्वायरी भी पूरी हो गई, सवाल जवाब भी हो गए। पूछताछ के दौरान यूनियन लीडर डिकास्टा ने मैनेजमेंट के आदमी को बहुत सारे सवालात किए। अब आगे क्या होगा?
देखो, इंक्वायरी तो अभी खत्म हो गई है। अब इंक्वायरी ऑफिसर अपनी रिपोर्ट मैनेजमेंट को सौंप देंगे।
लेकिन सर, रिपोर्ट में क्या होगा?
देखो, रिपोर्ट में वो सारी चीजें होनी चाहिए जिसके लिए इंक्वायरी का गठन किया गया है, जैसे कि गवाहों के बयान, कागजी गवाह, और ये सब सुनने के बाद में फैसला। अगर ऐसे रिपोर्ट में ये फैसला, ये फाइंडिंग ही दिया नहीं है तो ये रिपोर्ट अर्थहीन है, ये तो याद रखना चाहिए।
सर, मैं अपने आप से यह पूछता आया हूँ कि इस इंक्वायरी रिपोर्ट में क्या क्या लिखते हैं।
जोशी, देखो, जैसे कोई दवा मरीज को सूट होनी चाहिए, वैसे ही चार्जेस को मद्देनजर रखते हुए रिपोर्ट्स लिखी जानी चाहिए। ये जरूरी नहीं कि रिपोर्ट कोई बड़ी हो या छोटी, मगर ये बहुत ही जरूरी है कि इंक्वायरी के बारे में सारी जानकारी उसमें मौजूद हो, सो उसकी गरिमा बनी रहे।
और सर, उसमें क्या नहीं आना चाहिए?
देखो, ऐसे रिपोर्ट्स में कोई भी चीजें बढ़ा चढ़ाकर नहीं लिखनी चाहिए, जैसे कि ये नए ताजे आए हुए रिपोर्ट में एक फाइंडिंग, ये आदमी इस समाज में क्या इस धरती पे रहने के लायक नहीं। अरे, इसकी कोई जरूरत नहीं है। देखो, कोई भी विशेषण न चिपकाया जाए। मिसाल के तौर पर अगर आप किसी कर्मचारी के बारे में लिखते हैं तो ये एक सड़ा हुआ आम है, ऐसे वाक्यों के प्रयोग करने की क्या जरूरत है?
तो फिर इंक्वायरी रिपोर्ट की सर्वोत्तम टेस्ट कौन सी है?
देखो, कोर्ट के मुताबिक यह रिपोर्ट तांत्रिक दृष्टया पूरा न हो, क्योंकि इंक्वायरी ऑफिसर को कानूनन तौर पर सभी बारीकियां जानने की जरूरत नहीं है, उससे हम अपेक्षा भी नहीं रख सकते।
सर, रमेश की रिपोर्ट तो अब मैनेजमेंट के साथ होगी। अब हमारी मैनेजमेंट इस पर क्या निर्णय करेगी?
देखो, अभी इस मैनेजमेंट इस पे थोड़ा विचार करेगी, थोड़ा सलाह मशवरा लेगी।
क्या उसके बाद तुरंत सजा सुनाई देगी?
सही समझा जाए तो ये रिपोर्ट की जांच होने के बाद रमेश को सजा सुनवाई जा सकती है, उसकी सजा माफ भी की जा सकती है या उसकी सजा की अवधि कम भी की जा सकती है। देखो, मगर ये करते हुए एक महत्वपूर्ण बात है, इस रिपोर्ट की प्रतिलिपि रमेश को मिलनी चाहिए और उस पर उसका जवाब भी आना चाहिए।
लेकिन सर, सजा क्या हो सकती है?
इसके लिए होमवर्क की बहुत जरूरी है। देखो, कर्मचारी का पूर्व वृत्त, उसकी मिसबिहेवियर की तीव्रता, इन सबको मद्देनजर रखना चाहिए और सजा देते हुए इन सभी चीजों को, गवाहों को सामने रखना चाहिए।
सर, सही मायनों में सजा का मूलाधार क्या हो सकता है?
ये तो नहीं होना चाहिए कि अचानक कोई भी पूर्व सूचना न देने से ही कर्मचारी को सजा सुनाई जाए, राइट? और दूसरी बात, कर्मचारी को इसके बारे में पहले ही मालूम होना चाहिए कि उसके कौन सी सजा मिल रही है।
रमेश के बारे में क्या होगा? हाँ, आपको क्या लगता है?
आपके लिए इसकी कोई अहमियत नहीं है जोशी। रमेश का क्या होगा, इससे भी महत्वपूर्ण बात है इस विषय को जान लेना। आखिर आप तो एक मैनेजर ठहरे।
Isn't it an everyday affair? Now let's see, after the submission of inquiry report, who decides the punishment?
After the inquiry report is submitted, to whom? This question appears great, but the answer is very simple. Who appointed the inquiry officer? It is the disciplinary authority. So after the inquiry report is over, the inquiry officer should submit the inquiry report to the disciplinary authority for taking appropriate action. The disciplinary authority will go through the inquiry report, go through the charges, the scanning of the evidence on record, the conclusions and the reasons of the inquiry officer, and ultimately come to a judgment as to what sort of a punishment is to be given or meted out to the concerned charge-sheeted workman.
Now, can the disciplinary authority differ from the views expressed by the inquiry officer?
The inquiry is held by the inquiry officer. Depending on the rules which are applicable to the particular organization or even the standing orders, the inquiry officer may suggest or might not suggest any sort of a punishment. Now, if he has suggested a punishment, the disciplinary authority might just say that it agrees with the views or the punishment as suggested by the inquiry officer. Now, it might happen this way, that the inquiry officer has held a concerned workman guilty and the disciplinary authority declares him to be innocent. Well, in this case, the employer or the disciplinary authority is just exercising his rights, his inherent rights as an employer for pardoning his employee. This is allowed. Well, in the next situation, it might also happen that the inquiry officer has held the concerned workman to be innocent and the management or the disciplinary authority wants him to be held guilty. It might do so interpreting the same inquiry report, but in this sort of a situation, as per a recent ruling of the Bombay High Court, reasons have to be recorded and hearing, that is the right of audi alteram partem, which is a principle of natural justice, has again to be given to the concerned charge-sheeted workman.
Can the past record be considered by the disciplinary authority in finalizing punishment? Let's see that.
As regards the past record, the disciplinary authority has only to understand that the past record is to be seen in making a decision as to what exact punishment is to be meted out to the charge-sheeted workman. There are a galaxy of punishments, right from dismissal, discharge, removal, demotion, stoppage of increment, censure, warning, out of which what is the exact punishment to be given. Now, the inquiry officer has suggested a punishment. The disciplinary authority sees the past record and it also finds that if the past record is a totally hopeless record, that in the past he is warned or suspended or so many of the things, some punishment is there in his past record, well then the disciplinary authority this time might think it fit to award a larger sort of a punishment or a higher punishment. If his past record is a very clean record or an unblemished record, the disciplinary authority might even think of pardoning the employee or even think of awarding a lesser punishment. Say instead of a dismissal, you award a discharge, or instead of a discharge, you just demote a person or stop his increment or simply warn him. All these things are possible, but past record cannot be the basis of the present punishment. Any present punishment which is based on the past record would be bad at law. Past record is only for helping the disciplinary authority to decide as to what exact punishment this time, that is presently, to be meted out to the concerned delinquent or the charge-sheeted workman. One thing should not be lost into oblivion or not be forgotten. That is, this inquiry report should be communicated to the concerned charge-sheeted workman, as well as this letter of punishment also should be communicated to him, maybe by authorized modes of communication, registered post or whatever it is which we have seen earlier.
Friends, in these 3 episodes, we discuss the basics of departmental inquiry in accordance with the principles of natural justice. We would like to have your comments and queries about these educational programs. We have many such programs in store for you. Please keep in touch with us. Thank you.